No, but if we play our cards right, we're about to turn and burn on these things. So just as long as the senator from the 41st won't be objecting to everything.
We can just do these by acclamation.
Secretary, read House Bill 61.
House Bill 61 by Representative Seabaugh of the 34th and others, a bill to be entitled an act to amend Code Section 40-2-151 of the Official Code of Georgia annotated relating to annual license fee for operation of vehicles, fee for permanent licensing of certain trailers, and fee for new passenger car with paid title ad valorem taxes, so as to provide for the issuance of separate license plate for hearses and ambulances, to provide for related matters, to provide for an effective date, to repeal conflicting laws for other purposes. Mr. President, the Senate Committee on Public Safety recommends that this bill do pass by substitute. Respectfully submitted, Senator Albers of the 56th District Chairman. Mr. President, the Senate Committee on Public Safety offers the following substitute to House Bill 61, a bill to be entitled an act to amend Chapter 10 of Title 15 of the Official Code of Georgia annotated relating to magistrate courts so as to provide for magistrate court jurisdiction over certain proceedings, to amend Code Section 16-7-21.1 of the Official Code of Georgia annotated relating to unlawful squatting so as to revise offense provisions, to amend Article 1 of Chapter 21 of Title 43 of the Official Code of Georgia annotated relating to rights, duties, and liabilities of innkeepers so as to provide for certain guest removal procedures for innkeepers, to provide for an affidavit, to amend Title 44 of the Official Code of Georgia annotated relating to property so as to provide for limitations on law enforcement officer safety regarding removal, to provide for legislative findings, to authorize real property owners to request assistance from law enforcement for the immediate removal of squatters from their property under certain conditions, to require such property owners to submit a verified complaint, to provide for complaint requirements, to provide for law enforcement requirements, to authorize arrest of squatters for legal cause, to authorize a fee for service, to provide for law enforcement and property owner immunity in certain instances, to provide for civil remedies, to provide for criminal penalties, to provide for definitions, to provide for an effective date and applicability, to provide for related matters, to provide for a short trial, to repeal conflicting laws, and for other purposes. Mr. President, Senator McLaurin of the 14th offers the following amendment to House Bill 61. Amendment 1. Amend the Senate Committee on Public Safety substitute to House Bill 61 by replacing lines 135 through 137 with the following. Accommodations were provided on a day-to-day or week-to-week basis, provided, however, that a guest who resides in a room for 90 days or more in a 100-day period of time shall be deemed to be a tenant under Chapter 7 of Title 44. For purposes of this paragraph, the term reside shall have the same meaning as set forth in Code Section 16-7-21.1.
Mr. President,
Mr. President, Senator Halpern of the 39th and others offers the following amendment. To amend House Bill 61. Amendment 2. Amend the Senate Committee on Public Safety substitute to House Bill 61 by inserting to provide for construction after an affidavit on line 7, by inserting to prohibit access to courts of dispository proceedings under certain conditions after, so as on line 8. Mr. President, that completes the order.
Recognize the senator from the 48th.
Thank you, Mr. President. House Bill 61 is, if you look in your folder, no longer a license plate bill. This bill was replaced last session because the underlying bill was passed elsewhere with a bill from the senator from the 56th. This bill clarifies the difference between innkeeper and guest. For over 100 years in our state statute, we have had this language clarified. There is a difference between a landlord-tenant and an innkeeper, hotelier, and a tenant or a guest. It defines that. So when innkeepers have a guest at their hotel, and that is the official language is innkeeper for a hotelier, they have a relationship that you're paying, whether it be a day, a week, an extended stay, months at a time. And we all know that in this world, in this state, there are those that are unable to maybe be able to do a first and last month's rent, to be able to get an apartment. And so extended stays become their home of choice, or maybe out of necessity. But what it does do is it gives them that option to decide what it is they're going to do. It allows them to decide, this is the best place for me to go. Or maybe it's a worker, someone that is working, on a project. They're away from home for an extended period of time. This clarifies that relationship, because when someone chooses to stay at a hotel or a motel, whether it be extended stay or not, and they choose not to pay, they are staying there unlawfully. And arguments have been made that hotels make enough money, or that, as my good friend, the senator from the 14th, put on our desks, efficiency lodge, promoting that there are those that offer stays, whether it's a night or forever. And that's okay, because that's their right. As a business owner, that's their business model of what they're doing. What this bill does is it clarifies that someone can choose to occupy a room, but if there's an interruption in payment, what happens next? Many of you have discussed this with me over the course of the better part of a year. This bill was on our calendar a year ago, and we chose to pull it because we knew that there was more work to be done, that we needed to take into consideration, what does this mean if maybe a young mother and child were staying in an extended stay hotel, a nonprofit was paying for that hotel, and there's an interruption in payment, a credit card lapses, or maybe some other event that causes them to have an interruption. In working with the minority leader, the minority whip, with countless advocates from the homeless community, we crafted a very, very comprehensive, well thought out amendment, which is Amendment 2 on your desks, that explains that if there is an interruption, that there is a process, that there is a time of up to 10 days to work that out and make sure that we can get payment reinstated and that they can continue to stay there. But what we cannot do is legislate and force private property owners to enter into a different type of contractual relationship, to switch from innkeeper to tenant, to make it like an apartment type situation. This bill cannot do that. Any amendment to the contrary can't do that. It's not fair to force a property owner to allow someone to stay for free just because someone doesn't have another option. The Amendment 2 that's on your desk speaks to that very plainly, that if there is an interruption, there is time to cure that, satisfy the payment, and continue to stay there, or don't continue to stay there. But it is unlawful. And we have seen evidence of this very, very recently, just a few weeks ago in Gwinnett County, of a bad actor who fraudulently went into a hotel, committed credit card fraud, A post-certified member of the Gwinnett County Police Department went there to remove him, and he was shot and killed doing his job because of non-payment, because there was no mechanism to try to get them properly evicted and deal with that. This bill will hopefully prevent issues like that from happening again. The Amendment 2 that's on your desks, I believe, gives the proper amount of time to satisfy any questions or concerns about how much we care about those that are unhomed, those that are forced to stay in extended stays longer than they'd like to. But it makes sure that we are showing compassion to that we have worked together to do this. You know, about an hour ago, we were honoring the senator from the 15th for all of his work to this chamber. And our minority leader made a statement that really resonated with me. He said that he hoped that we would honor the senator from the 15th by proving and showing that our handshake is our word. In my 4 years in this chamber, I have learned that with him. Many of you have been here far longer than me. But what I do know is this, that the compromise that went into Amendment 2 was not only a handshake, it was a year's worth of work between industries that had never had peaceful negotiations and conversations before. I want to thank my dear friend, the Minority Whip, for working with me on that. I appreciate the senator from the 39th, the 41st, the 22nd in crafting this amendment. And I know that with your favorable consideration on this vote, we will have been able to thread the needle on the clarifying language and still showing that we have been thoughtful and caring about making sure that we don't wrongfully evict people that by no other choice of their own have to use an extended stay hotel as their primary residence. I'm happy to answer any questions if you have any.
You do have a couple questions, Senator. Recognize Senator from the 33rd.
Thank you, Mr. President. I ask for unanimous consent to excuse the senators from the 28th and 35th.
Okay, Senator, we'll get them here in a second. We're just taking questions right now.
Oh, okay.
Recognize Senator from the 41st.
Thank you, Mr. President. Senator Yield.
Of course.
Senator, thank you. I just have a series of questions to reiterate some of the things you've already said. Senator, isn't it true that you and I and several of us in this room have worked in good faith with one another over the year to come up with compromise language?
That is very true.
Senator, isn't it true that the best way to know that compromise has worked is when both parties leave a little bit unhappy?
That is the best way to define compromise.
Is it not true that there are people in the hallway who normally love me who are a little bit unhappy about the compromise that we have come up with?
If they are unhappy, then they do not understand the effort that you have put into this, and I appreciate your efforts.
Thank you.
You have no more questions, Senator.
Thank you. I yield the well.
Recognize Senator from the 9th. Actually, hold on, Senator. I apologize. I got to let the people that have done amendments first. Recognize Senator from the 14th to explain amendment number 1.
Thank you, Mr. President. Thank you, Mr. President. I rise to speak in support of Amendment 1 and to explain my concerns with this bill. I'll go ahead and give kudos to members from my caucus and the senator from the 48th on the work they've tried to do to reach compromise, but we have to be honest with the public about that compromise. That compromise is under the shadow of a House bill and a majority caucus position that is not going to leave us much room to do the right thing by Georgians who are vulnerable, who are in search of housing. That compromise is crafted given the political realities of what people think is possible under the Gold Dome and not necessarily what should happen. So even though compromise can be a good thing, and in this case is a good thing, I will be voting for Amendment 2. I think Amendment 2 makes the bill better. I have also presented Amendment 1 for your consideration because I think that the voters of Georgia, the residents of Georgia, people who find themselves in this vulnerable position deserve to have this public policy put up for consideration within this chamber. And the difference between what Amendment 1 does and Amendment 2 does, actually I'll start with this, they are technically compatible in the sense that they modify different parts of the underlying bill. So if you wanted to vote for both amendments, you could, and it would not be inconsistent in terms of the text of the bill. There might be some lawyer implications that get cleaned up in the House, but procedurally we can vote on both 1 and 2 today if that's something that you would like to do. But let me talk about this advertisement. If I could direct your attention to the advertisement for Efficiency Lodge. Everybody should have a copy of the ad on your desk. Efficiency Lodge's advertisement says, "Stay a night or stay forever." That's an advertisement to stay at Efficiency Lodge. So the clear implication of this business's advertisement is they want you to stay at Efficiency Lodge. Forever, the literal meaning of forever is longer than 90 days. So I think we'll go ahead and take it as granted that Efficiency Lodge is advertising stays that are longer than 90 days for individuals who may not have much in the way of other options or places they could go rent an apartment. And I appreciate the candor of the senator from the 48th that sponsored this bill in acknowledging the phrase business model. That this is in fact the business model of places like Efficiency Lodge, is that they seek to advertise to folks with housing instability that this is an acceptable, reasonable, affordable option to solve their housing insecurity. Now, why is that important? In the law, there are many places where Georgia law, state law, federal law, everywhere acknowledges that when you avail yourself of something, that's a legal term of art, when you avail yourself, meaning when you approach somebody else under the law and say, I want to have this relationship, that is a reason why the relationship you're asking for should be applied, should be recognized under the law. When you go solicit business, when you, even when you're driving by an accident, and you see somebody by the side of the road who's injured, you change your own legal rights and duties by stopping your car to try to assist somebody who is in need of help on the side of the road. So the law recognizes many places where you change rights and responsibilities by going up to another person and saying, I want to have a certain kind of legal relationship with you. In this case, you've got a hotel and innkeeper industry that is trying to have its cake and eat it too. The having its cake is that they want to be able to keep advertising to vulnerable people with housing insecurity to say, we want you to think of us as a reasonable, safe, affordable option for a long-term stay, a forever stay. But the eating of the cake is to say, well, if you find yourself to be too vulnerable, if your housing insecurity is too significant, we want to be able to usher you quickly out the door and make room for other customers or just not have you on our property. But that's not how apartment complexes have to conduct themselves under the law. Apartment complexes who advertise for extended stays have a whole bevy of rights and responsibilities that come with the notion that their tenants are staying there for a long period of time. And that's why other states, besides Georgia, have a 90-day rule. Virginia, states like North Carolina, have a rule that anywhere you stay for longer than 90 days, as this business model suggests that you should do, you get the rights of a tenant under Georgia law. So I've heard remarks today already about fairness What's fair? Is it fair to the business owner? Is it fair to the property owner? Well, what's the other side of that equation? What's fair to the person who is induced, who is invited by the business's advertisement to stay for longer than 90 days? Is it fair to treat that person like they're an overnight bed and breakfast guest? Because we've seen pictures of the rooms that folks live in an extended stay. At about the 30-day mark, 60-day mark, 90-day mark, you're not just thinking about where your backpack stays in the room overnight. You're not just thinking about, did I leave my phone charger? Did I get all my clothes out of the hotel room before I leave? You're starting to settle in. You're starting to think about this place on the wall that's blank. Maybe it'd be brighter and happier in the room if I put up a piece of art in that little blank place. What about my meal plan for next week? I've got to figure out, do I have a refrigerator in here? How much space does it have? What hot plate or implement am I going to use to cook food? Do I have a budget for going out to eat? 90 days for people who are experiencing housing insecurity is a very long time. Now, it might be the blink of an eye for a business with an Excel spreadsheet, but for the people who would or potentially might be experiencing homelessness, if it were not for these opportunities, this is life. It's everyday life, and it is the most important source of security that they have. So I want to rebut a couple things you heard this morning from the senator from the 48th. This is not a free pass, this amendment to establish the rights of a tenant. This is not free housing or free lodging. All this is rights, legal rights that apply in the landlord-tenant relationship, meaning the right to cure. A similar right as would be created in second, but a little more robust. The ability to go through a magistrate court process, to force a formal notice process, an eviction process. Enough rights to ensure that that housing insecurity, which, by the way, that housing insecurity is the reason that they were drawn in like a tractor beam in the first place, according to this business model, that housing insecurity does not eat that person alive with a summary eviction or kick-out process that doesn't have the same rights as a tenant. So I think that's what's really fair. I think what's fair is Amendment 1, because we've, for a very long time, already identified a legal balance, a fairness, an even-handed way of approaching this issue in the realm of landlord-tenant law. That is what's fair, and that would be the best public policy. And the last point I'll make is a political one. Virginia and North Carolina are very interesting states for Georgia to be talking about in an election year. These are states that have been tipping in the direction of a different party's rule for some time. And I think when you look at the breakdown of even Democratic voters, the number of Democrats who identify as moderate, voters that y'all might have been appealing to in the past, those voters see stuff like this and they think it's a good idea. Amendment 1. They see basic fairness, good meat and potatoes policy that doesn't unduly prefer business owners and large corporations over vulnerable people. They see that balance and they say, that's what I want my moderate government to do. This is not some kind of lefty Bernie Sanders stuff we're talking about, right? This is pretty down the middle of the road, good public policy to balance the interests of corporate owners with the most vulnerable people who are specifically invited to stay on these pieces of private property. So I'm no Nostradamus. Amendment 1 might fail, but Georgia voters deserve an even-handed, sober discussion about the rights of vulnerable people in these contexts, and that is why I've submitted Amendment 1 for your consideration today. Of course, like I said before, if it fails, I will be supporting Amendment 2 and the compromise language that was worked out, but I will be voting against the bill if it doesn't include Amendment 1, because I think we owe the most vulnerable people in a year where we're talking about affordability more than Amendment 2 gives them. Mr. President, I'll yield for any questions.
You do have a few questions, Senator. Recognize the Senator from 37th.
Does Senator yield?
I do.
Appreciate the example you shared. You know, stay a day, stay forever. Do you believe that the extended stay facilities in our communities add value and are an important part of our what's available for as places for folks to lay their head?
I think, so I've used the metaphor in this chamber, and I'll give you a yes, no in just a second. I mean, the answer is yes, but let me explain. I've used the metaphor in this chamber before of airline seats reclining, right? I love that metaphor of when the airlines decide to pack everybody in really close, that all of a sudden, you know, row 34 and row 35 get in a fight because of the operation of the seat back. And it's easy to get mad at each other, but who you should really be mad at is the airline who's crammed you in like sardines, right? And I think a similar thing is true about housing insecurity. When we don't fund the Housing Trust Fund, when we don't have affordable housing policy that creates enough supply to bring down costs, I mean, we've been debating the LIHTC in here. When we don't create enough supply for people for rent to come down, then we find these folks who are essentially stuck between homelessness and question mark. Like, what's the other option? And so this is a stopgap option. And unfortunately, the nature of the market power, the asymmetry in market power, functions in such a way that those people are really at the mercy of the corporations that choose to engage in this business. And then politically, they don't have the political power to push back against bills like this that try to tip the balance more in favor of the corporate owners. I think a good analogy, too, would be payday loans, right? Industries where the target audience, the market, essentially, for these industries is to take vulnerable people who have no other option and present them with the only other feasible option that exists, but to tilt the balance of power incredibly far in favor of the corporation because they have that power, because there is no other option. So I answer your question, yes, that they provide an important role in the community. They play an important role, the extended stay places, but I think there's to use the author's word of fairness, there's a basic fairness consideration that has to apply where we don't just let it be exactly like payday loans, where we build a balance into this bill that other states have built in, that 90-day rule that sufficiently protects the vulnerable people who are using it for housing.
Yeah, thanks for your answer to my yes or no question. My question was, though, and the concern I've got is we safeguard the tenant-landlord relationship in Georgia very carefully. There's a covenant that's entered into, isn't it true, between tenants and landlords. And because of that, we give tenants rights because they've paid a security deposit. They're typically leasing for longer terms. It is a place that's considered permanency. And in that back and forth, that two-way agreement, that covenant, we protect that relationship very carefully. What we have here, though, however, this is the concern with Amendment 1. If you impose this, what we're doing is that there will not be advertisements that say stay a day or stay forever. The advertisements will say stay a day or stay 89 days. These products and these opportunities are so important, isn't it true, for people to have a place to stay, that we can't drive them out of business by imposing a relationship we safeguard very carefully in law, which is tenant-landlord, by imposing that on that which is an extended stay. So my question is this: isn't it true that if we impose tenant-landlord on these, we will drive down supply, as we've seen? Supply has been driven down of these because of the exposure that businesses that want to provide a great service feel like they can't provide anymore, because this is the exposure to this kind of treatment is exactly what keeps them from bringing more product into the market. Isn't it true?
It's not true. I reject the notion that the landlord-tenant relationship is a very careful, sensitive, precious legal relationship that we keep in a lockbox free from interference from policymakers like ourselves. It is, in fact, a long-standing framework that recognizes the importance of protecting vulnerable people who rely on housing once they have invested a certain amount of time in the housing. And I think, let me say this. I remember I was in a mentorship program when I was in college. And you're assigned to a student. I had a middle school student I was assigned to. And they told us at the beginning of the mentorship program, if you can't commit more than 6 months to this relationship, you're actually doing harm to the child. It would be better if you never mentored the child to begin with, because the child is creating an expectation that you are a reliable person in their life who they can turn to for mentorship, for emotional support. And so we would prefer you not participate in the program at all if you're not going to stay for 6 months. This idea of availing yourself, again, like the person at the side of the road, if you avail yourself of a relationship, you need to be able to come correct. And so my suggestion to you, Senator, bold as it might be, is that it would be better for these extended stay places not to exist at all if the way they're going to do business is to continue to make ads like this, but then put people on shaky ground for 90 days or longer and pull the rug out from under them. And, Martin Luther King Jr. was the one who said that sometimes the path to justice requires fostering such a tension, creating such a crisis, that we actually address the real problem instead of pretending to address the problem in ways that are actually more harmful than doing nothing at all. And so if, Senator from the 37th, we had a companion bill today to regulate these ads, to force them to say only 1 to 89 days, I might be more persuaded. We have no such bill on the floor. Instead, we are going to continue with business as usual with these advertisements and the business model, but we are not going to provide the safety net for individuals after 90 days that Virginia, North Carolina, and many people of good common sense think is the correct balance. Thank you, Senator. Any other questions?
Recognize Senator from the 33rd.
I think he wants to excuse folks. Yeah.
Recognize the Senator from the 20th.
Thank you, Mr. President. I was going to ask you the same question as he did, but you answered that. I guess my question, I have a couple of them, if you don't mind.
Please, Mr. Pro Tem, yeah.
Give me a real-life example of, so if they get the rights of tenancy under your amendment, then what is then the process if you needed to evict them for like not paying or for tearing up
Sure.
your property or for being disruptive to the other guests, loud, or
Sure.
criminal activity, or trafficking, suspicion of human trafficking, those kind of things?
Sure.
What then is the process to remove them? It's a longer process, I'm assuming.
I really appreciate that question. I think that's actually a great question, and it opens up a couple cans of worms that are really important to discuss on this bill. I tried to keep my speech at a high level as long as it already felt. But in the weeds, there's a couple issues. So number one is this bill creates a mandatory process by which law enforcement is required to charge people with criminal trespass and to essentially get involved in a very heavy-handed way early on without any magistrate, without any judge involved. I don't think law enforcement love that. I mean, I've been told not to speak for law enforcement in here. However, I do think it's safe to say that law enforcement don't love being thrown into the middle of conflicts without magistrate oversight. This is a booting issue, too. Quick shout out to the booting issue that law enforcement don't love. Hey, I got it in there. Law enforcement don't love being called out to adjudicate disputes that are not managed by judicial oversight. So that's number one. Number two is, yes, it does create a right to an eviction process through a magistrate court, that it gives you a little more time, a little more judicial process. But I want to raise the point about why we'd be in that situation in the first place. Let's say, for example, that an extended stay location has a tenant that has stayed over 90 days, that is engaging in something horrible like human trafficking, drug trafficking. There's almost certainly a level of notice that the extended stay company has that this is going on if it's been happening for 3 months. And so it really stands to reason to ask the question, again, a lot of this conversation, we're putting the onus on the tenant. What about the landlord? Why is it that an extended stay property would allow for a nuisance for that period of time? And I think that raises much bigger questions about their business models. So my point in response would be that even if it's a longer process after that 90-day mark, you're talking about a corporation that already has fair notice that there's a problem that they should be handling. And I think we need to put some of that onus back on the property owner to deal with that problem instead of just the tenant. But I thank you for your question.
So do you mind another question? Will
Go
you
ahead.
yield?
Sure.
I probably could get on board with your amendment, I think, if it was 90 consecutive days, because if you're staying 30 days and then you're vacating for 3 days, and then you come back and stay another 30 days, vacate for 3, and come back and do another 30, they would fall under your amendment. And that, to me, is not your narrative about hanging pictures and stocking your refrigerator and really making it your home.
Yeah.
That doesn't hold water if they're moving in and out.
So, Ms. Pro Tem, let's bring that Monday energy back, because I'm ready for it. I would be amenable to an amendment that says 90 consecutive days or more. The other thing I want to draw your attention to is line 4 of my amendment says 90 days or more in a 100-day period.
Right.
So
why not consecutive?
If the Pro Tem wants to co-sponsor an Amendment 1A with me.
This isn't my issue, really. So,
okay.
But if you want to offer that, I mean, I'm not going to draw up an amendment.
I would be happy to offer the amendment to this amendment. I think.
But I don't know if we're going to have time.
The Pro Tem's point is well taken. And again, I don't want to ambush y'all with a policy that doesn't apply elsewhere. These other states with moderate sensibilities are doing this policy, and I think they think it reflects a fair balance. So I really appreciate the Pro Tem's openness to that conversation.
Recognize the senator from the 52nd.
Thank you, Mr. President. Will the senator yield?
I do.
So I have rental property. I have no use for squatters, all that. However, I do have one concern in this bill. If you've got a family that has stayed in one of these for many months, their mail's there, their children are getting on the school bus there, and they're not a day late in any of their payments, then I think with this bill and Amendment 2, they could still be removed within 10 days. Would that be correct?
Yeah, the senator is absolutely right. So this is yet another can of worms I didn't open in my initial remarks, which is that the only protection that Amendment 2 provides against removal is protections as to rent, is my understanding. The 10 days to cure, there are other pretexts. And again, there's some legitimate issues relating to trafficking or other nuisances, but many landlords and extended stay places will resort to pretext to justify removing somebody from a room, even if, as Senator from the 52nd identified, they're current on rent, they're not behind in payment. So again, imagine a situation where someone is current on rent or on payment. Now you have a second tier of tenancy that Georgia law would be creating under this bill that would not provide the protections of a judicial process in case an extended stay company resorted to pretext or something false to try to justify immediate removal and charging with criminal trespass by law enforcement. Thank you for the question, Senator.
Got a couple more questions.
I won't torture y'all too long. I do want to make sure to talk to my whip.
All right. Recognize the senator from the 41st.
Thank you, Mr. President. Does the senator yield?
I do. Thanks, Senator.
Senator, I just wonder if you would be willing to help kind of paint a picture of the types of families that we're talking about. So isn't it true that when it comes to extended stays, we are often talking about women with children who are staying in an extended stay because they cannot rent a rental due to perhaps an eviction that's on their record, or perhaps they can't come up with the 3 times the rent that's necessary. Is that not true?
That is absolutely 100% true, Senator. It goes back to that airline metaphor that the seats are squeezed. We're talking about folks who are on the margins of society. You know, their situation's very squeezed, and this is kind of the last resort.
Do you further yield?
I do.
Isn't it also true that we're talking about often children who get on the school bus in front of the extended stay hotel in which they're staying in?
Yeah, that's right, Senator, and I believe the Senator for the 52nd made that point as well.
Yes, do you further yield?
Yes.
Can you just extrapolate and tell us what are the implications on a child seeing a parent, a loved one, being arrested for criminal trespass if this were the underlying bill were to come into law? Well, just tell me about the ramifications of that.
Senator, I'm not a licensed psychiatrist, but what I do know is that there are formative years, like the kind you're describing, where messages from society about belonging really matter, where if you feel like you don't have a stable home, you don't feel the psychological security to try to start a business or invest in your own education, or think that all the stable frameworks that you need to succeed in this life, if they're not available to you, you pull back a little bit and you don't want to try as hard. And so, you know, there's a cycle that comes with poverty. This is what people refer to as the poverty trap, that some aspects or conditions of being in poverty are self-reinforcing, that they cause other habits and patterns that make it even more difficult than it already was to succeed and to pull up by the bootstraps, or whatever other phrase we want to throw at that issue. And so when people say housing is kind of a fundamental, well, is a fundamental right that is the bedrock of many other rights, this is what they're referring to, is that the stability that housing affords a family and a child is the foundation upon which that child builds their future psychological and economic success.
One final question, if you'll yield.
Sure.
This speaks to the Second Amendment. Senator, is it not true that we begin to chip away at some of this problem when we remove eviction records evictions from people's records, particularly when they actually were not evicted or after 3 years? It's not true that we begin to really address the kind of the bedrock issues that are resulting in people being locked into extended stays in the first place?
Yes, Senator, and that is why the opening of my remarks I said I congratulate you and the senator from the 48th on a bipartisan compromise in Amendment 2. Unlike the senator from the 18th, I'm in favor of the Second Amendment. And so quick joke there, he didn't hear it, that's okay. But I just want to say, I mean, the Second Amendment moves in the right direction, but the First Amendment is what Georgia deserves. And I'm happy to vote for both of them. Thank you, Senator. Thank you for your time today. I think it's an important discussion. I appreciate y'all's attentiveness to it. Thanks, Mr. President.
Who authored the amendment number 2? Is that you, Senator from the 39th? All right. Senator, I recognize Senator from the 39th.
Thank you, Mr. President. So I rise to speak to Amendment 2 that is before you. As you heard from the author from the senator from the 48th, this amendment is the result of a thoughtful collaboration with housing advocates, the hotel and tourism industries, and other stakeholders to arrive at a balanced approach to the issue. So just a quick reminder that the underlying bill contemplates what happens when hotel guests fail to pay. And make no mistake, there are plenty of bad actors who will squat if that pathway exists for them. It also recognizes that hotel workers are put in danger when they attempt to remove guests for non-payment. So this amendment does address what we spent some time already talking about and discussing, which is that across our state, there are families or individuals living in extended stay hotels, not for a night or for a week, but for months, and in some cases, years at a time. So this amendment does two very clear and reasonable things. First, it says that if someone's been living in a hotel for more than 90 consecutive days, they should not be put out overnight for non-payment. They should be given clear notice, at least 10 days, to respond before needing to vacate. They must respond within 10 days, not indefinitely, but they have a defined process. And the amendment also explicitly states that the innkeeper and guest can agree to an alternative remedy in lieu of removal. So that should not be controversial. That is common sense. Second, the amendment addresses something that's quietly locking families out of housing altogether, and that's how eviction records follow people long after their case is over. So right now in Georgia, if you have an eviction filed against you and you win the case or resolve the issue, you do everything right, that filing can still follow you indefinitely. And in today's housing market, that one record could shut many doors because screening companies are not consistently updating those outcomes. Families are judged on those filings and not on the facts of the case. And when that happens, they don't just get denied, but they get pushed into places like extended stay hotels, and then they get stuck there. So if a family's resolved their case, met their obligations, or prevailed in court and still can't rent because of an outdated or incomplete record, that is not accountability, but an absolute barrier, and it's one that we've created. So this amendment is not one-sided. It is balanced and deliberately so. The 90-day provision says no sudden displacement after months of staying somewhere. And the record provision says no permanent punishment after a case is resolved. So this amendment will still allow businesses to operate. It still allows enforcement, but it introduces something that we don't have enough of right now, which is both fairness and clarity. So I ask for your favorable consideration of Amendment 2 because it addresses both ends of the problem. It provides stability in the moment and then a real pathway forward after. I will yield unless there are questions.
You have no questions, Senator.
Thank you.
We have another late arriving amendment here. Secretary, read the caption.
Senators McLaurin of the 14th and others offers the following amendment to House Bill 61, Amendment 1A, by replacing 90 days or more in a 100-day period of time on lines 4 and 5 with 90 or more consecutive days. Mr. President, that completes the order.
Senator, do you want to speak to your second amendment? I don't know how you can cover much more than you did the first time.
At the suggestion of a senator who will remain unnamed because he didn't sign it, but you might have heard it on the Senate floor already, there is an Amendment 1A I did not draft. It was drafted at the suggestion of that senator, and I'm pleased that the senator from the 21st also signed it. It is just to clean up Amendment 1 to make it clear that it's 90 consecutive days or more to establish the right to tenancy, not 90 days and 100 days, so that the pro tem's question about cobbling together days is resolved. That's all the amendment does. Thank you, Mr. President.
Recognize the senator from the 37th. Speak to the bill.
Mr. President, ladies and gentlemen of the Senate, I rise today to speak in support of House Bill 61, and I want to provide some context for this. This is a very important policy debate, but it's one that I think we need to think through very carefully as we act and consider these amendments. As we talked about earlier today, the extended stay product within our innkeeper guest ecosystem, if you will, is very important. Extended stay hotels in the metro, and particularly the outer lying rim of the metro area where a lot of folks live that perhaps don't have the resources to stay in more expensive areas. A hotel night is about $150 a night. A traditional hotel rented night by night by night is about $150 a night. Extended stay, if you're careful and you find a place that provides good service, you can get them as low as $350 a week. Now, that's not cheap. For the size of the room, the square footage, it's relatively modest, but $350 a week is 1/3 of the price per night of an individual hotel room. Now, why do people need this? Who's in need of these kind of extended stay facilities? Families, single moms perhaps, who can't afford the high security deposit. Maybe they don't have the money to put down 2 months or 3 months rent in a place. Extended stay is an option for them as a bridge to get them from point A to point B. In many cases, people need temporary lodging. They might have a lease that's ending on a certain date. They can't move into another place that's within their financial means at another date, and they need an extended stay to carry them in between that. It's an economical means, and it provides a very important product in our market to support those people. Extended stays play a vital role in our economy. Think about out-of-town workers. You bring workers from different construction organizations, different service organizations. They move, or they live where they live, but they're moving into Atlanta or around the metro or anywhere around the state for a job. Oftentimes will stay in extended stay hotels because, as we said, the price per night is about 1/3 the price of a night by night by night rental. Now, if a construction worker that's coming in, a blue-collar worker coming into town to work on a plumbing job or a masonry job, they can't afford $150 a night out of their salary. Extended stay is the perfect product for them to be able to operate and do what they do for a living and do it economically. The concern I have with what's being talked about, what's being contemplated by the senator from the 14th and his amendment is we recognize the importance of these products. In fact, the senator from the 41st, the distinguished minority whip, talked about the reason folks can't move sometimes into actually hotel tenant landlord relationships is they have bad credit, or they may not have the cash to be able to put down for a period of time to be able to get into a more larger, more accommodating, more lavish place to live. They're vitally important to our communities. For people, low-income folks, people who have short stay needs, and workers who move from place to place with their blue-collar jobs. Extended stays fill this very important need, and the ability to fill this need cannot exist. It cannot exist. It will not exist if we impose on what is otherwise an innkeeper-guest relationship, if we impose a requirement for a landlord-tenant. As I alluded to earlier in my questioning with the senator from the 14th, the landlord-tenant relationship is a covenant. Tenants put down a security deposit, 1 month, 2 months, in some cases 3 months, and they sign agreements that they're going to be there typically for a longer period of time. Typically, although there are month-to-month leases, typically it is a 6-month or 12-month requirement to be able to be in a tenant-landlord relationship. Very often. That's very, very often the case, as we know. If all we have is sleeping in the woods or a tenant-landlord relationship, we're missing something. I'm sorry, there'd be three options. Staying in the woods, paying $150 a night on a night-by-night rental, or having a tenant-landlord relationship. But that's the only thing that's available to people. Our economy is missing out on something that's vitally important, the ability to drive down the cost per night to stay places for a week or a month, or maybe a couple months, at an economical price. I've got single moms in my district who have been out of work. They've had interruptions. They might be working two jobs. They might have lost one job, so their income has been severely depressed. These kinds of extended stays are very important to catch people and be part of our safety net. For folks who can afford to pay something, but don't have the economic ability to get into a tenant-landlord relationship long term. They're just in that place. They need these products. The reason this bill is so important is these bills assure, by protecting the people who bring these products into existence, that they're not going to have their kindness and their enterprise as innkeepers weaponized by our laws. The current status of our law weaponizes kindness. It weaponizes the due process of our courts to let folks squat in these facilities. Some of them are squatters who do this in a calculated way. In other cases, there's people who have fallen on hard times, but they've not invested up front in the security deposit. They've not been paying at a level that's commensurate with people owning these facilities and being able to enter into this tenant-landlord relationship. To have a viable tenant-landlord relationship, there's got to be a covenant between the tenant and the landlord. The economics have to work. It's not about landlords exploiting tenants. It's about landlords wanting to bring a product into existence and being able to stay in business. You know, some of the discussion we saw during COVID, this idea that you can't evict people. There was people had fallen on hard times, but the problem we heard in this very legislature was when people were not allowed to move people out who were not paying. What's the landlord to do? What is a landlord to do who's trying to provide a fair product that's decent, that's occupiable, that meets building code, it's a decent place to live, if someone never, ever, ever pays? If they've got to go through thousands of dollars of attorneys, they have to go through weeks and weeks and weeks of process to try to evict somebody who's simply not paying, what is the landlord to do? It's a balance. I serve here because I care about regular people. I don't serve here because I care about landlords. I don't serve here because I care about powerful developers or powerful business interests. I serve here for regular people. My concern is, without House Bill 61, the products that serve regular people, the products that my constituents need to have for them when they're out of town on business, or when they have a little interruption between where they're staying, or they need a place to stay for a period of time in transitioning from home A to home B, without this careful balance being maintained that House Bill 61 seeks to maintain, the services my people need, people that are in need, there will be no product there for them. These products are not being brought into existence in the metro area because folks have figured out to weaponize kindness. They've figured out to weaponize the due process within our legal system to take advantage of what they're asserting is a landlord-tenant relationship and what is on its face very clearly innkeeper-guest. Friends, House Bill 61 is vital to maintaining the supply of extended stay opportunities for people who are in need. If we blow up this balance by imposing landlord-tenant in a circumstance that ought to be innkeeper-guest, the people who need these products, whether they're blue-collar workers working out of town for a couple weeks and they need to pay $350 a week for a place to stay instead of $1,000 a week, or moms who lost their second job and they're trying to find a way to kind of bridge between one apartment to the next when they can actually move in. These products are essential in reality, not in theory, not in concept. They have to exist. There is a shortage of supply in many parts of our metro area in these products, and unless we pass House Bill 61, that shortage of this vital part of our business economy is going to continue to have shortages and will not be able to serve the people that so desperately need them. House Bill 61 strikes that balance, and I would encourage you to support the amendment by the senator from the 39th, but not the amendment by the senator from the 14th, because it violates the balance we're trying to strike. With that, Mr. President, I yield the will.
Recognize Senator from 36.
Thank you, Mr. President. Colleagues, I rise to add some more information to this conversation that I think is vital. A little bit more about the history of this bill that's the language that's before us now. This bill was introduced in the House last year. It did not pass out of committee. Could not make it out of committee. It didn't come over here after a thorough vetting by the House and going through the Rules Committee process and coming to the floor and having a vote. No, not at all. It couldn't make it out of committee, you know, which says to me, speaks volumes about the issues and problems with the bill. Another piece of information I'll share with you is that the Georgia Supreme Court in 2023 had before it a case, Efficiency Lodge, where have we heard that name before? That's the crowd that's advertising, come for a night, stay forever. You know, that Efficiency Lodge. So they're in the Supreme Court, Efficiency Lodge versus Neeson. And the Supreme Court ruled, our Supreme Court here in Georgia, in 2023 ruled that in some conditions, people living in extended stay lodging could claim a landlord-tenant relationship. That was the ruling. Then they come running down here to us to pass a bill to undermine the Supreme Court ruling. So follow me on that. That's not insubstantial. So this narrative of these struggling innkeepers who are holding body and soul together and extending this opportunity to people that don't have permanent housing, they are raking in money like bandits. I mean, they are making, this is a very profitable business model, is my point. That has not been stressed here, I don't think, much in the debate. It is highly profitable. And they went all the way to the Supreme Court to try to get by with their way to resolve a tenant situation. And if you look at the rates that are being charged, they're doing no one any favors. It's like people that are down kind of at the bottom in terms of it could be from domestic violence, it could be from losing a job, it could be from massive medical bills, all the ills that can beset us as we go through life, and they're in the posture that they cannot. They're going to live in a car, or as somebody up here said, live in the woods, and this is where they wind up as an alternative to that. And when they did this extensive study here in DeKalb County, I mean extensive, some 50 or 60 pages of analyzing this situation. If you pay, survey respondents reported paying rates with an average monthly hotel cost of $1,852, just about what an average two-bedroom rental in DeKalb County cost. And more than 30% of those who were polled paid daily the most expensive option. So you're down and out, and then you've got a situation where you're being milked for your last penny, to keep a roof over the head of your family. get those kids out there for the school bus that morning and get off to work 1, 2, 3 jobs. So we're being asked to undermine a Supreme Court ruling. That's number one. Let's get clear on that. And the reality is, and it's been referenced here from the well today, that we have housing insecurity in significant part because we don't have enough housing in Georgia. Our state does not invest enough money in affordable housing. Far from it. And now we've debated on the floor, and bills have moved forward to get our hands on these investors that are finding it very profitable to buy or build housing in our state that's rental housing. And when they buy a development of houses and then switch it all to rental, and jack the rents up. So these are realities that are forcing people into this kind of extended stay situations that are rife with problems for families. We have rejected, I think just in the last week, an effort to put before the body for a vote raising our minimum wage. In Georgia, it's $5.25 an hour, good people. It's $5.25 an hour. And I know if you think about it for 10 minutes or maybe 2 minutes, it sends chills through you to think of trying to raise a family on $5.25 an hour. But we've rejected the opportunity that we have to raise it to $15. Those are pathways. Those are part of the structure that we're operating in this state that create the housing crisis, not enough of it, not enough investment in affordable housing, and then these poverty wages that are in our law books. And you can look at how much this impacts children, because guess what? It's not a secret, but we don't talk about it nearly enough, and we certainly don't act on it. But these systemic conditions that people are asked to live under do great damage to our children. And the DeKalb analysis of actually we've got a statewide. There's a chart that shows in each one of our counties how many children there are that are unhoused or living. Are homeless or living in these extended stay situations. And in my county, Fulton, there are over 1,800 children between pre-K and 12 that are homeless. 26% of that number are in extended stay hotels. 26%, 1/4 of those kids, and it's 2% of the total student population. That doesn't even count the children that are younger than pre-K. So when we're casual or worse, when we turn a blind eye to this situation and don't deal with it, you're impacting the lives of these children in ways that and trauma from which they are scarred permanently in all too many cases. Now, I will also add this. These families are paying rent. They're just not receiving proper housing for the rent that they pay. It's just a reality. You've got the impact on kids living in situations. These rooms offer far less than an apartment, no full kitchen, no private laundry, limited space, and often reporting mold and dreadful living conditions. In addition to which, all too often, and the police can certainly share you the records of how they get called to these locations because the proprietor is turning a blind eye to drug dealing that's happening, to trafficking that's happening, to preying on children that's happening. And I don't mean by that hardworking family that's in there paying this astronomical rents. I'm meaning that they're preyed on because the proprietor does not keep the facility safe, sanitary, and properly run for it but then you're going to pay these sky-high rents. These sky-high, a studio apartment in DeKalb costs $1,500. Well, that's nothing compared to what the people are charging, paying daily and weekly to stay in these places. So the balance to me is way off. We're not balancing in this situation. We have families subjected to very substandard living conditions, and then a proprietor that can kick them out for any number of reasons. They don't have a tenant landlord-tenant relationship, and that's what the amendments that we have before us, I think 1 and 1A, I believe they are, would create. So we've got a very profitable business model going on for the proprietors. Very profitable. They wouldn't be in the business, guys, if they weren't making money hand over fist. And they took it to the Supreme Court to try to keep on doing that. And our Supreme Court ruled, no, that's a landlord-tenant relationship that has existed here, and you have to abide by it. So I would urge you to vote for the amendments. We're far from fixing the underlying structural problems, that we have the authority, the power, and I'd say a mandate from voters to address this in a broader way around what people get paid for their labor and whether or not landlords and proprietors are held to account for the conditions they raise. It's astronomical rent levels and dreadful living conditions, and then they want us to take apart the Supreme Court ruling from 2023. I'd say that's a bad proposition. I will yield for any questions, and I'll certainly yield
no
well
questions,
if
Senator.
there are none.
You have no questions.
Thank
Senator.
you.
Recognize the Majority Leader.
Mr. President, I move the previous question.
All right, move previous question. Is there objection? All right, here we go. Objecting. All those in favor of the motion to move the previous question will vote yea. All against it, vote nay. Secretary, unlock the machine. Senator from the 48th. Senator from the 48th. Senator from the 48th. Do you want to close? Get over here and get on deck. On the motion to move to previous question, yeas are 29, nays are 21. This has prevailed. Senator from the 48th, you can close.
Handshake deals, policy or politics. Amendment 2 is a year of handshakes, a year of policy, a year of doing things right. Amendment 1 is politics. The author of Amendment 1, the co-author of Amendment 1A, didn't stop to ponder the fact that those hotels in your districts After 3 months with no contract, 3 months of just getting by, and that's okay, for whatever their reason, they can stop payment. What is that going to do to the rates when you have people that are unlawful guests that are staying there? What does that do to that property owner? When we look at the state of North Carolina that was referenced multiple times, in North Carolina, they have a process called summary ejectment. The sheriff removes somebody following a court order with a writ of possession. That time is 14 days. That's a longer period of time than what we have in Amendment 2. So Amendment 2 is actually doing more for people than trying to switch into these different types of relationships. It's giving balance to what we're doing, and they could stay there for 90 days, they can stay there for 2 years, they could stay there indefinitely. To my friend, the senator from the 37th, he described in detail that if people just switch into a rent-type situation and it moves away from the innkeeper-tenant that we have now, or guest, excuse me, the innkeeper-guest, if we go to tenant, what does that do? It changes forever the relationship of what hotels are meant to be, what they have been for over a century in this state. And while I think an attempt at well-meaning from Amendment 1A, it does not solve this issue. It makes the relationship less clear. It will create a massive increase to rates that are charged. And the unintended consequences of this are unimaginable. A year of working on this versus an amendment that was introduced the day of. And an amendment to an amendment that was drafted from a conversation that took place against that wall just a few minutes ago. I urge you to vote no on Amendments 1 and 1A. They will disrupt the entire relationship and balance that we have. Please vote yes on Amendment 2. Please vote for the underlying bill, and let's do the right thing by our business owners and by those that need long-term stay hotels. Thank you.
All right, the question is on the adoption of Amendment 1A, authored by the senator from the 14th. Is there objection to 1A? All right, with objection. All right, all those in favor of 1A will vote yea. All opposed, nay. Secretary, unlock the machine. On the adoption of Amendment 1A, the yeas are 24, the nays are 26, and this amendment has failed. Moving on to Amendment number 1, authored by the senator from the 14th. Is there objection? There is objection. All those in favor of Amendment 1 will vote yea. All opposed, nay. Secretary, unlock the machine. Senator from the 16th. On the adoption of Amendment 1, the yeas are 22, the nays are 28, and this amendment has failed. All right, now we're on to Amendment number 2, authored by the Senator from the 39th. Is there objection? Without objection, Amendment number 2 is adopted. Is there objection of the previous question being ordered? Is it on the adoption of the committee substitute as amended? Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute as amended is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 32, the nays are 18. This bill, having received the requisite constitutional majority, is therefore passed by substitution. Where's that representative at? Well, I tell you what, Representative, you better be glad I like you. If I'd known that thing would have been debated an hour and 45 minutes. Woo! Woo! All right. All right, let's see if we can get through some of these things here. Secretary Reed, House Bill 541.
House Bill 541 by Representatives Dempsey of the 13th and others, a bill to be entitled an act to amend Code Section 20-3-411 of the Official Code of Georgia, annotated, relating to definitions regarding tuition equalization grants at private colleges and universities, so as to expand the definition of an improved school to include certain institutions which offer programs in nursing, to provide for related matters, to provide for legislative intent, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Higher Education recommends that this bill do pass. Respectfully submitted, Senator Burns of the 23rd District Chairman. Mr. President, that completes the order.
Recognize the Senator from the 25th.
All right, ladies and gentlemen, this bill has to do with nursing shortages in the state of Georgia. It is anticipated that we're going to be very short of nursing in the near future, just like we are now, and it's only going to get worse and worse. What this bill does, it allows this Chamberlain University to participate in the tuition equalization grants. This college puts out RNs. They're ranked third, second highest number of nurses passing the state board. So they are a brick and mortar school, and this is just going to help us ease our nursing shortage. I'll be glad to take any questions.
You have no questions, Senator.
Thank you. I ask for your favorable consideration. Thank
Does
you.
any other senator wish to speak for or against the measure? Chair hears none. Is there objections to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. Report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. Main question is ordered. Questions on the passage of the bill. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 45 and the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. We've got a lot of members, so just so you know, I know the pro tem's got some food in there. We're not going to break for lunch because we've got a lot of members that are trying to get out of here because they have other obligations. So we're just going to go through. We're going to go pound through these things as fast as we can. If you're hungry, go in the ante room. If you're not hungry, then sit right there and vote. All right, here we go. Moving on to House Bill 907.
House Bill 907 by Representative Jones of the 47th and others. A bill to be entitled an act to amend Article 31C of Chapter 2 of Title 20 of the Official Code of Georgia, annotated the Completion Special Schools Act, so as to require certain local school systems to either be a party to a collaborative operating agreement with the Completion Special School or provide certain education programs and services to students in grades 9 through 12, to require local school systems to provide to Completion Special Schools the contact information for students who stop attending or withdraw from the local school system, subject to condition and expectations, to provide for related matters, to repeal conflicting laws and for other purposes. Mr. President, the Senate Committee on Education and Youth recommends that this bill do pass. Respectfully submitted, Senator Hickman, Chairman. Mr. President, that completes the order.
Recognize the senator from the 48th.
For those of us in this chamber, in this building, there are two Jan Jones in our lives. One, the First Lady of this body, and the other one, my mentor across the hall. This is the final bill of an illustrious 24-year career by Speaker Pro Tem Jan Jones. This is HB 907, Completion Schools, and probably one of the most important bills that we will vote on this year. I hope there's no controversy on this one. We need to all come back together and start rowing in the same direction. But this is what the bill does. It requires completion schools to provide associated school systems with their available programs and classes and instructions on registration for credit recovery or academic intervention. It requires school systems to make the information available physically on campus and electronically to parents and students. It makes plain that parents shall be permitted to register their student directly with a completion school to attend one or more classes. We can fight about taxes, we can fight about hotels, we can fight about a lot of things in this room, but the one thing that we are all on the same page about is getting more kids across the finish line, more kids graduating, more kids reading well. And this does that by including dropout prevention and academic intervention for kids that need it most. I'm happy to answer any questions, or I can yield the well. Thank you, I yield.
Any other senator wish to speak for or against the measure? Recognize the senator from the 38th.
Thank you, Mr. President. I want to first start by saying I've had the honor and privilege of working with Speaker Pro Tem Jan Jones in my capacity in the world of charter schools. She's been a steadfast supporter and someone that I've spent time in her office to ensure that we are doing right by students across this state whose family choose that as an option to educate their children. But I also want to address what just happened in this chamber. I was silenced. And because I was silenced, I'm going to use this opportunity to speak out for many of these students that we're trying to help. As I've shared plenty of times before, I am a former high school principal, and I educated students who lived in extended stay hotels. I intended to get up here and share my concern of these students and many families across this state of being kicked out of hotels that they rely on for housing. And I'm furious because this is not theoretical to me. I have a family member who lives in these hotels. It's not temporary. It's not for 90 days. They've lived in these hotels for years. And I will go a little bit further to be a little more transparent. It's not a family member. I see smiles and, oh, what is Kemp doing? It's a sibling. And so because this chamber takes 2 hours to do personal points of privilege, or we get out early when the house is across the way doing work, we call the question on issues that are going to kick families out of homes that they rely on. Right now, we have a situation in which people are paying as much as $2,386 a month because they cannot qualify to live in apartments or homes in their communities. They could be paying around $2,000 a month. So we have an issue. And so I intended to get up here, Mr. President, and share the fact that these families don't live in these houses by choice, but because that is what they can qualify for, and that is what stability looks like for them. We have children whose families are living in these hotels because that is all their parents can qualify for. And so what we just did is we made it easier for extended stay hotels to kick these families out. The Georgia Supreme Court said that these families has just as many rights as folks who live in rental homes and apartments in this state. And instead, what we just did is we sided with property owners who are banking on the fact that people are going to rely on these properties for shelter. We sided with them and said, you know what? Go ahead, kick them out without any due process, despite the fact that our Supreme Court across this street said they have a right to tenants' rights just as anyone else. And so please pardon my passion, and if I'm out of order, I'm out of order, but my button was pushed and I was not acknowledged. So I needed to take this time to address the fact that I stand in firm opposition of what we just did. And Mr. President, I yield the well.
Does any other senator wish to speak for or against this measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor of the bill will vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 46 and nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Secretary, read House Bill 946.
House Bill 946 by Representatives Clifton of the 131st and others. A bill to be entitled an act to amend Title 27 of the Official Code of Georgia annotated relating to game and fish so as to authorize hunting and trapping of feral hogs under certain circumstances, to repeal provisions relating to wildlife control permits for feral hogs, to authorize location of feral hogs with unmanned aircraft systems, to provide for related matters, to repeal conflicting laws and for other purposes. Mr. President, the Committee of the Senate on Natural Resources and the Environment recommends that this bill do pass. Respectfully submitted, Senator Anderson of the 24th District Chairman. Mr. President, that completes the order.
Recognize the senator from the 24th. And the senator from the 24th is going to show you how to present a bill, get in, get out, and have everybody vote for it. And no filibustering. Some people just like to hear themselves talk.
Thank you, Mr. President. I hope everybody really listened to you just then. Maybe they can learn something. Ladies and gentlemen, I bring you House Bill 946. We just talked about educating our children. Well, let's get them after school's out, let's take them hog hunting. This bill is, all it simply does is make it the way you can take a drone and locate feral hogs that destroys and damage your property that farmers have and people have private property. And this way we can reduce the amount of hogs, feral hogs that we have that's destroying our property. I just ask each and every one of you vote green so we can go kill some hogs this afternoon. Thank you so much. I ask you to vote green. I yield the will.
Senator's yielded. Do you have a question, Senator? He's yielded. No. Don't need to take. You good. You good. You good. You.
In parliamentary inquiry.
State your inquiry.
Parliamentary inquiry, Mr. President. What's the difference between a hog and a hog?
Depends on if you're below the gnat line or not.
Well done.
Yeah. All right. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of committee, which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor of the bill vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 46 and nays are 0. This bill having received a requisite constitutional majority is therefore passed. Secretary read House Bill 987.
House Bill 987 by Representative Jones of the 25th and others, a bill to be entitled and add to amend Chapter 8 of Title 34 of the Official Code of Georgia annotated relating to employment security so as to provide for portable benefit plans and portable benefit accounts for independent contractors, to provide for definitions, to provide for voluntary contributions, to provide for independent contractors to opt into withholdings, to provide for independent contractors to opt out at any time, to exclude voluntary contributions from establishing the classification of employer or employment, to provide for related matters, to provide for a short title, to repeal conflicting laws for other purposes. Mr. President, the Committee of the Senate on Insurance and Labors recommends that this bill do pass. Respectfully submitted, Senator Harbin, Chairman. Mr. President, that completes the order.
Recognize the Senator from the 48.
It's me again, third time today. All right, we're done after this, I promise, or at least I'll be sitting down. HB 987, the Voluntary Portable Benefits Act, gives us for the first time ever the ability for gig workers to get insurance that will follow them where they go. There's a letter on your desks signed by a number of great organizations ranging from the Realtors to NFIB to the Chamber that talks about what this means to our economy, what this means to those that don't have access to health insurance because they're not a W-2 full-time employee. So for an independent contractor, this bill permits the creation of this portable benefit account where they can opt in to have the hiring entity and a fixed dollar or percentage of their fee to their account. Let that sink in, y'all. 1 in 6 Georgians had a full-time job 15 years ago. Today, that's 1 in 4. 1 in 4. This is one of the most important bills we can do for giving health care access to those in a gig economy. The bill explains it. It's very simple. It's very straightforward. I believe that when we're looking at those in a gig economy and what the future holds for our state and our country, this is probably one of the best things we can do for them. Happy to yield for any questions. Awesome. Ask your favorable consideration on House Bill 987. Thanks.
Recognize the Senator from the 44th.
Thank you, Mr. President. I am rising in support of this piece of legislation, and I definitely co-sign a lot of the comments made by the senator from the 48th. This is an issue that I have worked on for a number of years, and as a matter of fact, led a study committee working with the Georgia Chamber as well on portable benefits with the pro tem. Goodness, and it was a while ago now, probably six, maybe even 7 years ago. But this is a concept that when I first learned about it, light bulbs really went off for me, because the reality is our system of benefits in our country has been set up in a way where they were mostly tied to traditional forms of employment, when people stayed at jobs for a really long time, coming through the employer, and that just isn't the reality of a lot of work in our modern era. And that extends beyond such things as gig economy type jobs, which is kind of the most common context where you hear of the need for portable benefits. Gig economy normally when you hear that, we're talking about the Ubers and the Lyfts and the DoorDashes and all of those. But there are plenty of other folks that want to be able to chart their own business or be hired as a consultant, or say, you've got your own graphic design business, meaning that you would not have traditional benefits accessible to you. And if you don't have traditional benefits accessible to you, there are all kinds of consequences with that. And it's far more than just, I might not get an employer match on my 401k, right? I mean, you wouldn't have access to paid time off. Healthcare is obviously huge, retirement savings. I mean, all these things that are kind of needed to set oneself and one's family up for any kind of financial security long term are just not set up for you the way they are if you're getting all of that through an employer. And that obviously has a lot of consequences, some of which would end up falling back on taxpayers, A. But B, another benefit of setting up systems of portable benefits is that it not only recognizes the reality of our economy these days, but it also ensures that the economy can be more dynamic, because a lot of people aren't going to leave jobs to start their own company or, do what have you if they lose their benefits. And that's, going to lock them in place. Sometimes we call it the golden handcuffs, I guess. Usually that's more tied to, that phrase is more tied to salary. But in this instance, many people are not going to leave a job to try to start a business if they are going to lose all their benefits. So starting to envision how we can have this system that stays with the person and allows all of this dynamism and flexibility through our system really makes sense, because the old days of someone getting one job with one company and staying there 30 years is unfortunately not the reality. Fortunately and unfortunately, not always the reality. And that's just growing. So we do need to just totally reimagine the benefits that were put into place decades ago that were tied very specifically in many ways to that relationship. So I'm just thrilled to see progress on this issue. I want to thank the representative from the 25th for carrying it along, or I'm sorry, I can say it, Representative Jones, for carrying it along, as well as the pro tem for working on this issue with me years ago. So I kind of think there probably aren't any questions, but I'm happy to answer any if there are.
Questions,
Perfect.
Senator?
Thank you. Urge your support, and I yield the well.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 44 and the nays are 1. This bill, having received a requisite constitutional majority, is therefore passed. Secretary read House Bill 1086.
House Bill 1086 by Representatives Chastain of the 7th and others, a bill to be entitled an act to amend Chapter 2 of Title 25 of the Official Code of Georgia, annotated, relating to regulation of fire and other hazards to persons and property generally, so as to require notice to be posted upon certain buildings of the use of light frame truss type construction, to provide for rules and regulations, to provide for enforcement, to provide for definitions, to provide for a short title, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, The Committee of the Senate on Public Safety recommends that this bill do pass. Respectfully submitted, Senator Albers, Chairman. Mr. President, that completes the order.
Recognize the senator from 56.
Thank you, Mr. President. Senators, if I can have your attention for a moment. If I could have everyone's attention for one moment. This bill that we're going to talk about right now is in the honor and memory of two fallen firefighters in our state. House Bill 1086 is also known as the Firefighter Preston Fant and Brant Chesney Firefighter Safety Act. These two men gave the last measure of devotion for their community and sacrificed their lives to run in when everybody else was running away. The bill before you today is going to make sure that any building that is not built up to the current codes, that has a light truss system, which is the roof, is going to be properly marked with the firefighter Maltese cross, so we know when we're going into those buildings that it is structurally unsafe, and we're not going to take any unnecessary risks unless someone else's lives are in peril. The memory of these two firefighters who served in DeKalb County and Forsyth County, Georgia, will forever be enshrined by the fact that we're going to protect all of our first responders moving forward. So I'd ask you today to light this board up green in the memory of them, the men and women they served with, and their family and friends they left behind. Thank you, Mr. President. I yield the will.
Would any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill. All those in favor of the bill will vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 45, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Secretary Reed, House Bill 1097.
House Bill 1097 by Representatives Petrie of the 166 and others. A bill to be entitled an act to amend Title 37 of the Official Code of Georgia annotated relating to mental health so as to provide for criminal background, license status, and registry checks for owners, applicants, and employees of certain mental health facilities, to provide for the Department of Behavioral Health and Development Disabilities to submit fingerprints to the Federal Bureau of Investigation and Georgia Crime Information Center for the purpose of background checks to find disqualifying records, to provide for maintenance of personnel files, to provide for procedures relating to applicants or employees with ineligible determinations, to provide for definitions, to provide for related matters, to repeal conflicting laws for other purposes. Mr. President, the Committee of the Senate on Health and Human Services recommends that this bill do pass by substitute. Respectfully submitted, Senator Watson of the 1st District Chairman. Mr. President, the Senate Committee on Health and Human Services offers the following substitute to House Bill 1097, a bill to be entitled an act to amend Titles 35 and 37 of the Official Code of Georgia annotated relating to law enforcement officers and agencies and mental health, respectively, so as to provide for covered individuals to submit certain for national criminal history background checks, to provide for procedures for authorized agencies to make fitness determinations. Mr. President, that completes the order.
Recognize the senator from the 29th.
Colleagues, I'm happy today to present this bill for our friend and Rules Chair from the 6th, It's a very simple piece of legislation. All this bill does is authorize the Department of Behavioral Health and Developmental Disabilities to conduct fingerprint background national criminal history background checks for certain individuals associated with groups and facilities that we allow to run our mental health systems here in Georgia, so that DBHDD would not only run all criminal history through GCIC, but they would also run it through NCIC and the FBI to make sure that we had all good actors operating within the services that are providing good health care to those in our mental health communities here in Georgia. And if there are no questions, Mr. President, I'll yield the well.
There are no questions, Senator.
Thank you, sir.
Does any other senator wish to speak for or against the measure? Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Question is on the adoption of committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 44, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Secretary Reed, House Bill 1182.
House Bill 1181 by Representatives Ballard of the 147th and others, a bill to be entitled and add to amend Article 2 of Chapter 3 of Title 40 of the OCGA relating to certificates of title for motor vehicles so as to require an application for certificate of title to contain or be accompanied by the last certificate of title issued by another state when such application refers to a vehicle last previously registered in another state and the applicant is receiving such vehicle upon inheritance, devise, or bequest. To amend Code Section 40-3-34 of the OCGA relating to transfer of vehicle by operation of law, termination of interest and joint interest with right of survivorship to provide for related matters to repeal conflicting laws or for other purposes. Mr. President, the Committee of the Senate on Public Safety recommends that this bill do pass. Respectfully submitted, Senator Albers of the 56th District Chairman. Mr. President, that completes the order.
Recognize Senator from the 18th.
Thank you, Mr. President. HB 1181, which was passed unanimously in the House, is a bill that cuts red tape for Georgia citizens. If this will benefit our military families in particular who have Fort Benning, Fort Stewart, these bases are along our state lines, and allow a decedent's car to come from the state where the state is domiciled directly to the first-degree relative who is inheriting the car. As it stands now, if somebody dies with a car out of state, the car has to be first titled in the state where the executor is, even though the benefactor is here in Georgia. This will just allow a skip to be stepped to get title in the state of Georgia. And this should reduce time, taxes, and costs to our citizens. And I urge your support for HB 1181. If there are no questions, I will yield the well.
You do well. Your light is lit up, Senator. So
we'll call
recognize Senator from the 42nd.
Does Senator yield?
He does.
You mentioned red tape, cutting some red tape. I'm just curious though, is this bill going to make it where you can start putting tape on like glass surfaces, like especially like doors? That way, if someone were to approach that door, maybe they would see it and not run into it.
This will not. This will apply to red tape and titling one's vehicle. Thank you for the question, though, Senator.
You're
from the
welcome.
42nd.
Thank you.
Recognize the senator from the 55th.
Senator, that was with the gentleman in the well yield.
Yes, sir.
Yes, sir. This is a real question. Does this have any impact if someone passes here in Georgia? For example, their mother passes, and the title is in the car, is in their mother's name, and the mother doesn't really have anything else. Would this bill have any applicability on transferring title to the only heir, or how would that work?
Sir, this will just allow an executor to not have to, that is located out of state, not to title the car out of state, such as in Texas, before transferring back to Georgia, even though the decedent may be here and the heir is here in Georgia.
Has there been any work for the convenience of those that are already in the state to pass transfer title?
This would only affect vehicles that are titled out of state, even though the decedent may have died here in Georgia. If the car was titled out of state, say a transient military family is getting stationed around from base to base, it just allows to skip the intermediate step of having to title the car in another state prior to obtaining title here in Georgia.
Thank you, sir. We'll talk to you about some work on transferring title here in the state. Thank you.
Here in the state, if the executor here in the state, they could do an executor's deed, just passing on to the benefactor or beneficiary of the car.
Thank you.
You have another question, Senator?
Yes.
You have no other questions,
Okay,
Senator?
I will yield the well.
Does any other senator wish to speak for or against the measure? Is there objection to the previous question being ordered? Chair hears none. Previous question is ordered. Is there objection to the agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. Yes, sir. Senator from the 49th, for what purpose do you rise?
Parliamentary inquiry,
State
Mr.
your
President.
inquiry.
Isn't it true that I am extremely happy that the senator from the 42nd has found a new obsession with the senator of the 18th rather than myself?
Senator knows what he speaks. Senator knows what. On the passage of the bill, the yeas are 43, the nays are 0. This bill having received requisite constitutional majority is therefore passed. Secretary read 1182.
House Bill 1182 by Representatives Rhodes of the 124th and others, a bill to be entitled and add to amend Article 3 of Chapter 12 of Title 2 of the Official Code of Georgia annotated relating to soil amendments so as to provide for additional prohibited acts, to provide for related matters, to repeal conflicting laws for other purposes. Mr. President, the Committee on the Senate of Natural Resources and the Environment recommends that this bill do pass by substitute. Respectfully submitted, Senator Anderson, Chairman. Mr. President, the Senate Committee on Natural Resources and the Environment offers the following substitute to House Bill 1182, a bill to be entitled and add to amend Article 3 of Chapter 12 of Title 2 of the Official Code of Georgia annotated relating to soil amendments so as to provide for additional prohibited acts, to provide for an exception, to provide for related matters, to repeal conflicting laws for other purposes. Mr. President, that completes the order.
Recognize Senator from the 24th.
Thank you, Mr. President. This evening I bring you House Bill 1182. This is a House bill that was that the EPD and also our Ag Commissioner is in favor of, Tyler Harper. This is a soil amendment bill where the trucks that bring in all the soil amendments will have to get off the road to unload. They have to get on the farm and unload or get out of the highway or the public dirt road. I ask you for your vote green so we can get the traffic keep flowing in our great communities.
All right, Senator, you have no questions. Does any other senator wish to speak for or against the measure? Is there objection to the previous question being ordered? Chair hears none. Previous question is ordered. Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Is there objection to the main question being ordered? Chair hears none. The main question is ordered. All those in favor of the bill vote yea. All opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 46 and nays are 0. This bill, having received a requisite constitutional majority, is therefore passed by substitute. Recognize Secretary read House Bill 1261.
House Bill 1261 by Representative Huddleston of the 72nd and others, a bill to be entitled an act to amend Part 1 of Article 2 of Chapter 5 of Title 48 of the Official Code of Georgia annotated relating to tax exemptions so as to provide for Level 1 Freeport exemptions for certain goods in inventory for electric utilities, to provide for application for such exemptions, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, the Committee of the Senate on Finance recommends that this bill do pass. Respectfully submitted, Senator Huffstetler, the 52nd District Chairman. Mr. President, that completes the order.
Recognize our former whip, our former majority leader, and I said former whip, and transportation chair, a man that has worn many hats in this esteemed body, and he knows how to be brief in the well.
The senator knows of which he speaks. Ladies and gentlemen, I'm here on behalf of our Rules Chairman, who is not here to present this bill. House Bill 1261 is an important piece of legislation for all of us. I don't have to tell you how important our utility companies are around our state. Our EMCs and our Georgia Power utility companies are often called up in the middle of the night to respond to power outages. I want to bring your attention to what happened 2 years ago when Hurricane Helene wiped out most of South Georgia. During that storm, we lost almost 10,000 utility poles, all the power lines, all the transformers, all the hardware and the equipment, and it took thousands of employees to be distributed from all over the southeast to southwest Georgia and southeast Georgia to help restore those lines. Just this year, we had a major ice storm in North Georgia where thousands of utility linemen had to relocate from South Georgia up to North Georgia, and they had to bring hundreds and hundreds of poles and equipment to those areas to restore power there as well. What this bill does is allow for a Freeport exemption for those poles, those utility lines, and those transformers and all the equipment to restore those power systems to those homes and businesses. It allows for the property taxes on that equipment to be exempt, but here's the process and how that has to happen. First, the local county commissioners have to pass an ordinance or a resolution to approve it, and then it has to go on a referendum in the local community, and the voters of that community must vote in favor of that Freeport exemption. This bill allows that to be set up and move forward, and I hope you'll support the utility companies in our state. Mr. President, I'm happy to yield for any questions, or I'll yield the well.
You have no questions, Senator.
Thank you very much.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agree until the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. All those in favor of the bill will vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 45, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Secretary read 1329.
House Bill 1329 by Representative Stevens of the 164th and others, a bill to be entitled an act to amend Chapter 13 of Title 16 of the Official Code of Georgia annotated relating to controlled substances so as to provide for certain provisions relating to Schedule 1 controlled substances, to provide for certain provisions relating to the definition of dangerous drugs, to provide for related matters, to provide for an effective date, to repeal conflicting laws for other purposes. Mr. President, the Committee of the Senate on Health and Human Services recommends that this bill do pass. Respectfully submitted, Senator Watson of the 1st District Chairman. Mr. President, that completes the order.
Recognize the man from Colquitt County. Gentleman from Savannah. You're up, Doc. The meter's running, Doc.
Sometimes you're just a little too busy. Thank you, Mr. President. I really appreciate you reminding me of that. So House Bill 1329 is the annual drug update. So basically, new drugs that come on the market or drugs that are moved in different schedules. There's a whole list there. Please don't ask me what they are, but this is the new and regular drug update annual bill. Thank you so much. I'll yield the well.
Is there any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agree until the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. All those in favor of the bill should vote yea. All those opposed, nay. Secretary, unlock the machine. Senator for the second. For what purpose do you rise?
Mr. President, parliamentary inquiry.
State your inquiry.
Mr. President, is it not true that the senators from the 1st, 2nd, 3rd, and 4th are daydreaming about I-16?
No doubt about that. No doubt about that. Those are all some pretty good men you just mentioned right there, too. Senator from the 5th, what purpose you rise? All in the passage of the bill, the yeas are 41, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Secretary Reed, House Bill 1374.
House Bill 1374 by Representative Hawkins of the 27th and others, a bill to be entitled an act to amend Chapter 24 of Title 33 of the Official Code of Georgia, annotated, relating to insurance generally, so as to provide for certain requirements concerning methods of payment to healthcare providers, to provide for definitions, to provide for notification, to provide for the avoidance of additional fees, to prohibit contractual waivers of certain statutory requirements, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, the Committee of the Senate on Health and Human Services recommends that this bill do pass by substitute. Respectfully submitted, Senator Watson of the 1st District Chairman. Mr. President, the Senate Committee on the Health and Human Services offers the following substitute to House Bill 1374, a bill to be entitled an act to amend Chapter 24 of Title 33 of the Official Code of Georgia, annotated, relating to insurance generally, so as to provide for certain requirements concerning methods of payment to healthcare providers, to provide for definitions, to provide for notification, to provide for the avoidance of additional fees, to prohibit contractual waivers of certain statutory requirements, to amend Part 1 of Article 3 of Chapter 5 of Title 50 of the Official Code of Georgia, annotated, relating to general authority, duties, and procedures relative to state purchasing, and for other purposes. Mr. President, that completes the order.
Recognize Senator from the 19th.
Thank you, Mr. President. House Bill 1394 has two parts that are kind of a little bit distinct. In the original House bill that came over, we had Chairman Lee Hawkins, former member of this body, worked several years ago to fix an issue where health insurance companies were paying providers via credit card. When they were paid via credit card, the credit card company, they'd obviously lose the 3 to 5% that comes in that credit card transaction. Chairman Hawkins at the time made sure that the providers could not be paid, or gave them an opt-out so they could opt out of the payment, the credit card payments. That's become cumbersome, confusing, probably at the behest of the insurance companies. So now what he is changing it to in Senate Bill 374 is an opt-in. If you want to be paid via credit card as a healthcare provider by the healthcare insurance company, then you have to opt into the credit card payments instead. This will likely cause more paper checks to be issued, which will allow the providers to receive a little bit more in what they've actually earned, probably 3 to 5%. I have championed for years something that's bothered me tremendously as I've chaired the budget, and that is folks coming into the contracting in the state at a certain level below a DOAS threshold, then renewing their contract above that DOAS threshold. It is infuriating to me that you could come in at $99,000 below a DOAS threshold and then renew the contract at $1 million well above that threshold and avoid the procurement process. So Section 2 evaluates or fixes that problem. It also fixes a problem that you may have heard from some of your local builders back home, that they would never be able to build a school because they've never built a school. In other words, they had to qualify first by building a school for ever being able to possibly build a school. What we say is that the RFQ or the RFP process, that's important. The qualifications are important, but they aren't necessarily outcome determinative in the bid process, and therefore someone who has not built a school before does still stand the opportunity to build a school in the future. They're not prohibited completely. That's obviously important as you have more and more folks who used to build schools in the past retire, move on, do something different. That's the total complexity of the bill. I'd appreciate your favorable support. Happy to take any questions.
You do have one question, Senator. Recognize Senator from the 42nd.
Does Senator yield? I yield. Does this have any impact on our local governments and contracts they might enter into? If it does, it was not intended to. It's meant to apply to state procurement in Title 50. I do.
So this would not impact any contracts our local government's doing with any entities or individuals, or the RFP or RFQ process at all?
If an amendment did that, I would consider it friendly, but again, it's meant to apply to just our DOAS process, where you could come into a contract under a bid amount and then renew it above a bid amount.
Do you further yield?
Are we stalling? Because I can talk longer.
I actually am.
Okay.
Tell us a little bit more of the history about how this issue came to you.
Well, as you know, in the middle of COVID, I was appointed to be the chairman of the Appropriations Committee. So as the chairman of the Appropriations Committee, I've had to review state contracts, review requests for budget items, and again, the thing that infuriated me most is that while we do have a very thorough DOAS process, Department of Administrative Affairs process, to review procurements, there is a provision that I feel is a loophole where one could come in underneath a dollar amount that's not covered by DOAS and then could possibly renew that contract above the DOAS amount, which then would require would essentially obfuscate the DOAS process, and that's just not good for anybody. How much longer are we waiting?
Do you further yield?
I yield.
Are you also daydreaming about how Interstate 16 yourself right now?
Well, you know, me and the senator from the 2nd share the love of the coast of Georgia and all of southeast Georgia. My son does have a t-ball game later on today, but I know we're going to get done and we're all going to make it there. And you need to be cheering for the Braves today at 5 o'clock. They're going to be doing really, really well, and those 4-year-olds are incredibly awesome, and as much as I love spending time with you, I know I'm going to enjoy that time a whole lot better.
You yield for just hopefully one more.
Okay. Yield.
In order to get to I-16, you have to get through Henry County, Interstate 75.
We do.
And as budget chair, do you agree that it's important that we make a very substantial investment in speeding up the process of adding new lanes through Henry County, so our lieutenant governor, even though you may have a house just north of Atlanta soon, still needs to make sure he can get back to Jackson as well? And it's important moving forward that those that are going to still be around this place continue to invest in great projects in the South Metro so we can get back and forth to Jackson, McDonough, Vidalia.
Yes. You know, the $1.7 billion investment that this body and the House of Representatives made into the reversible, now soon to be not reversible lanes on I-75 to move traffic better, traffic and freight throughout this state, are incredible investments that I know each one of you took personally, that I know each one of you are proud to have supported, that I know everyone in the balcony is there simply because they were here to make sure that we talked about those toll lanes today. And that because of your investment, specifically the investment of the senator from the 42nd, we will soon be able to alleviate the traffic in Henry County that many of you face daily. And we look forward to working on alleviating the traffic in North Georgia with the other $2 billion of investment that we intend to make in the FY27 budget.
You can now yield the well, I believe.
I yield the well. Senator from the 14th.
Thank you, Mr. President. I would ask unanimous consent that the rules of the Senate be suspended to allow the senator from the 11th to wear jeans.
All right. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objections to the previous question being ordered? Oh, you really have an amendment on this? You're stalling. I just thought you were trying to get TV time. What's my house rep doing in here today? Clint Crow, everybody. My house rep from Jackson, Georgia. They're not taking care of you over here? They messing with you, you let me know. Senator from the 45th. For what purpose you rise?
Thank you, Mr. President. Isn't it true that your rep has the best name in the House?
This is a possibility. It's a possibility. It's a strong name. Secretary, read the amendment.
Mr. President, Senator Hatchett of the 50th offers the following Amendment 1 to amend House Bill 1374 by adding after line 174, Part 3, Code Section 33-24-59.25, A health insurer shall not terminate, remove, or exclude a participating provider from its network during a plan year if such action would cause a covered person to lose access to covered services from such provider, and renumbering accordingly. Mr. President, that completes the order.
Recognize Senator from 50th.
Thank you, Mr. President. After hearing concerns from providers in my district and patients, sometimes insurance companies will drop a provider from their network in the middle of a year, which could potentially leave patients without access to their doctor and could cause them to have to go outside of their regional area or find new doctors because their health insurance no longer recognizes their doctor as an in-network provider. What this would do is just change the rules to where a health insurer can't terminate, remove, or exclude a participating provider from its network during a plan year if such action would cause a covered person to lose access to covered services from such provider. Happy to answer any questions, but I think this is a good amendment.
You have one question. You have one question. The pro tem. Recognize the pro tem.
Mr. President, I would ask for a ruling on the germaneness of this amendment, please.
Well, that I will yield the well.
After reviewing the amendment, the chair rules it non-germane. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. Previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to a report of committee which is favorable to passage of the bill? Chair hears none. Report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those in favor of the bill vote yea. Opposed, nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 46 and nays are 0. This bill, having received the requisite constitutional majority, therefore passed by substitute. Secretary read 1192, House Bill 1192.
House Bill 1192 by Representatives Taylor of the 173rd and others, a bill to be entitled an act to amend Title 49 of the Official Code of Georgia annotated relating to public assistance so as to provide for certain accounting practices by the Department of Human Services and the Department of Community Health, to provide for funds for specific purposes, to provide for annual review, to provide for annual reports, to provide for related matters, to provide for an effective date, to repeal conflicting laws and for other purposes. Mr. President, the Committee of the Senate on Government Oversight recommends that this bill do pass. Respectfully submitted, Senator Bearden of the 30th District Chairman. Mr. President, that completes the order.
Recognize. You have this? It's not clear on my thing. Senator from the 29th.
Thank you, Mr. President. And to start out with this, I have to recognize the senator from the 19th. Working as close on the budget as I had the opportunity to do this year, I would have assumed this was already a common practice. So to say that I was somewhat surprised that it wasn't, would be an understatement. But this legislation is very simple. This legislation requires that any funds, whether appropriated by the General Assembly or received from federal sources and designated for a specific purpose, must be maintained in separate accounts and not commingled or expended for other purposes by the Department of Human Services and the Department of Community Health. It establishes annual requirements for departmental reviews of practices and procedures to identify cost savings and operational efficiencies, with findings to be reported to relevant legislative committees. I just saw many times that we allocated funds for a particular area, and sometimes during the year, I don't think there was any criminal intent or anything like that, but department heads and CFOs and certain others would move that money in order to fill a gap that they found and spend it on legitimate needs, but it would be in an area that the funds were not initially designated for. So all this legislation does is require that this one particular department do this. If I had my druthers, all would be required to do this. We had to correct a few things from the amended budget to this budget so that some departments were in compliance with what this legislation is trying to do. But this is good legislation. It's fiscally responsible legislation. And I would ask that you, each of you, support this good legislation. And with that, Mr. President, I'll yield the well if there are no questions. Thank you, sir.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. On the pass of the bill, the yeas are 47, the nays are 0, and this bill, having received the requisite constitutional majority, is therefore passed. Recognize Senator from the 41st.
Thank you, Mr. President. Out of courtesy, pursuant to Senate Rule 7-1.10b, I give notice that on the next legislative day, I intend to move that the Senate consider House action on SB 350, a nice little local bill that we don't need to take a lot of time on.
Secretary, read the caption.
Senate Bill 350. By Senators Jackson of the 41st and others, a bill to be entitled an act to amend an act providing for the compensation of certain officers and officials of DeKalb County, approved March 31st, 1976, as amended so as to revise the compensation of certain judges, judicial officers, and county officers, to make conforming changes related to court names, to change by general law, to provide for related matters, to provide for effective dates, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Thank you for the note, Senator. Recognize Majority Leader.
Mr. President, I hope you and everyone has a great weekend. I move the Senate stand adjourned pursuant to H.R. 998 until 10 a.m. Monday, March 23rd.
Secretary, read them announcements.
The Rules Committee will meet upon adjournment in room 450 of the Capitol. Mr. President, that completes the order.
Majority Leader has moved that the Senate stand adjourn until Monday, 10 a.m. All those in favor of the motion signify by saying aye. All those opposed, no. The ayes clearly have it. Y'all have a good weekend. Take care.